Welcome to Close to Home with Nicole Sullivan.
Hi, everybody. Welcome to Close to Home with Nicole Sullivan. I'm Matt Skye. Nicole, a lifelong Mississippi Gulf Coast resident and experienced attorney, shares her legal insights on everything from real estate to estate planning, bringing clarity to a complex field. Nicole, thanks for joining.
Thanks for having me, Matt.
So jumping right in, let's understand the importance of a will and why is having a will so crucial for individuals and families regardless of their financial situation?
So I hit on this a lot in our last episode, but I like to consider a will an insurance policy. So it's super important to have, no matter if you have a lot of assets, a little bit of assets, whatever that may be. I would consider a will an insurance policy to make sure that your wishes are known, first of all. But also, if you don't have things titled appropriately and we have to go through probate, it's great to have that will to make sure. A lot of times there's this misconception that everything in Mississippi is automatically going to go to your surviving spouse, and that's not the case. And that's if you pass away without having a will. So especially when there is a married couple, it's important to make sure, if you're married and if you want everything to go to your surviving spouse, that you have a will that states that. Because if you pass away without having a will here in Mississippi and you're married, your estate is split between your surviving children and your spouse. But also not just surviving children, it could be predeceased children and their heirs. So there becomes a big issue when people pass away without having a will and still have a surviving spouse, because the intent most of the time is that everything goes to the spouse. And then once both spouses away, it goes to the children. But the default in Mississippi is not that way. So it's really important to have a will for that purpose if you want to make sure to take care of your spouse. But the other thing is, if you have a will and say there's a bad family situation and there is a child that you want to specifically exclude from your will, you need to be able to do that in your will. Because again, if you passed away without having a will, that child is going to receive that money. You know, everybody's situation is different. Everyone comes into my office and they think that their situation is novel, and it's so sad, truly, when there's a family situation that they feel like they have to leave a child out. But you don't know the situation and what has gotten them to that point. And a will is the best way to outline those things. So again, we make an attempt to estate plan to ensure that probate is not required. Probate is the court process where we have to present that will to the court to say, this is a valid will, this is how the assets are going to be distributed. The ultimate goal is to not have the court involved, but we have a will just in case. So that's why I say we need the will as an insurance policy. And again, it doesn't matter the value of your estate. So here in Mississippi, we don't have estate taxes. So when people pass away, their children aren't going to pay estate taxes here in Mississippi. The only time that estate or inheritance taxes come into play is if they hit that federal estate tax threshold. It's currently about 13.6 million. It changes. It varies by year. And that's something that we can easily avoid in Mississippi. Many people don't hit that threshold, but if they do, then I send them someone else, because I think that someone with an LLM, which is a master's of law in tax, is the person that's best suited for their situation. But many times people don't need that trust to avoid probate. It's also really important to have a will, even if you have very little assets, is to take care of your children, to make sure you name who's going to take care of your children. That's one of the most important things. It doesn't matter if you're 20 years old and have a child, or if you're 95 and have a child. At some point, you need to make sure, how do we take care of our children, especially if it's minor children. I mentioned in our last episode that in Mississippi, you're 21 as a minor. That's a little bit different. You're not an adult until you reach age 21 here in Mississippi. And that's a little different than most states, especially the people in the military that are moving here, or people that are moving out of state, maybe for warmer weather, whatever it may be. They may not be expecting that. So that's something I like to go over with people to make sure that they include that in their will. And again, it doesn't matter if you have $5,000 in assets or you have $5 million in assets. There's always a reason that we need to make sure that you have a will. And it could be simply just making sure that your wishes are known to your children, even though you've titled things appropriately. Sometimes people just want to put it in writing so that their children have an understanding of their wishes once they pass away. just to keep everybody on the same page. And I think that's important for being transparent with your family and understanding your parents' wishes. Because sometimes people come in and they're like, I don't understand why my parents wanted this. And I go through and I show them, here's what they did, here's what they said, and here's what they wanted. And we have to respect that.
That's pretty fascinating with that 21 age in Mississippi. I didn't know that. Pretty
fascinating. It's been that way since I've been practicing. So I assume it's been that way for a while. But it is interesting that the second you could buy alcohol, you're a adult in Mississippi, but not prior to.
So what are the essential elements that should be included in a will to ensure it accurately reflects a person's wishes?
This is another thing that we've gone over before, but to me, it's most important to have your executor listed. So your executor is the person that's in charge of your business affairs once you've passed away. A lot of times people think, well, I have a power of attorney. That goes past death. A power of attorney dies with you. Power of attorney is the person that can assist you with your business affairs while you're still alive. So your power of attorney dies with you, and then your executor becomes that person. The executor is the person in charge of your business affairs. Now, I also like to make sure that people have an alternate executor listed. The reason for that is you never know what's going to happen. A lot of times people name their spouse as their executor in their will. Many times spouses travel together. So accidents happen where both of them pass away at the same time. So then we have to look to the alternate. But also most of the time we don't have to probate a will until both spouses have passed away. So most of the time we're looking to the alternate to act as the executor because the first has passed away. So we like to have an alternate because you never know what's going to happen. So I like to make sure to plan for that. So we have our executor, our alternate executor. The next thing I really like to include in wills are any specific bequests or specific gifts that you have. So that could be jewelry, it could be specific property, it could be a family heirloom, a gun safe, a gun collection, knife collection, whatever it may be. You may have specific gifts that you want to give to your individual children. You may have $5,000 that you want to donate to your local church. You may have a sewing machine that you want to give to your great Aunt Martha. Whatever it may be, you list all of those things as specific gifts in your will. Then you go on to what's called, or what I call, the residuary clause. A residuary clause is the rest. So we've named all these specific bequests, but what happens with the rest of the things that we didn't name? So everything else that's left over, the residue of your estate, who does that go to? Now, a lot of times, again, it ends up being a spouse. So I give everything to my spouse, but then if my spouse predeceases me, who do we want it to go to? Many times it's children. Again, it could be split. I had someone come in this week that wanted to split it between her child, her 2 grandchildren, and a church. So it's split 4 ways between all of those people. You can do so many things with the residuary clause of your estate, but you just have to make sure you list that because you may forget about things. You may list every asset that you own in that specific bequest category, but say you inherit something later, or say you add a property and you forget to make a codicil, which is an amendment to your will, to add that property on. Most of the time, I don't like for people to list every single asset. I like for them to title things appropriately. So again, whether that's a savings account, checking account, retirement account, any of those things, list the beneficiaries on those. They're going to pass outside of probate. They don't really matter for the purposes of your will, because once you pass away, whomever your executor is just going to go to the bank and they're going to say, here, my mother's passed away. Here's her death certificate. Please just cut the checks pursuant to the beneficiaries that she has listed on her account. The banks will just cut those checks, and there's no need for probate or to get any court involved. It's just automatically there. So I don't always like to list all of those accounts in the will because they're already being taken care of. But to me, the most important aspects are going to be executor, alternate executor, specific bequest, and your residuary clause. There are a lot of other things that are important for considerations based on the situation, but I would say those are the most important things in a simple will that we would take care of.
So we touched on power of attorney. Are there different types of power of attorney, like financial, healthcare, et cetera? And why might they be important?
Yeah, so there are different types of power of attorneys. Typically, when we handle estate planning for people, we always suggest a will, a durable power of attorney, which is what you would call a financial power of attorney, and then also a healthcare directive, which is also a power of attorney for healthcare decisions. People call a healthcare directive an advanced healthcare directive. A living will has been something that I hear people call that, which to me is a little confusing to call it a living will. And I guess it's because it's your wishes for your life, I guess is the reason for calling it a living will, but I like to call it an advanced healthcare directive. And that's your power of attorney for healthcare decisions. So there's quite a few different types. Most of the time, we always suggest a will, a durable power of attorney for financial decisions, and then a healthcare directive, which is the power of attorney for medical decisions.
Jumping into that living will, why is it so necessary for estate planning or a healthcare directive, I should say?
Again, to each their own and how they want to describe it. My just preferred terminology is advanced healthcare directive. But I think the healthcare directive is almost more important than having a will. It's important for doctors to know who to speak with making any kind of end of life decisions. And the way I handle an advanced healthcare directive, when people come in for estate planning with me, I always send them with a sample. I send them with a sample to take home. I tell them to do this as their homework. That's where they go through and they read through it and they say, if I'm ever permanently unconscious, do I want food and water through a tube? Do I want to have any kind of life-sustaining treatment? I want them to go home and think about those things, pray about those things. I always make the joke, have a glass of wine, whatever you do, make those decisions at home and then bring that back with you. And we'll use that as a cheat sheet when we create your real healthcare power of attorney. And it's so important to me because not only do the courts need to see who to look to, but it's most important that the doctors know who's going to be your healthcare proxy, who's going to be that person that the doctors look to when you can't make decisions for yourself. So the law always protects you in that you can make decisions for yourself so long as you're able. But there are situations when you're not able anymore. Say you're in a coma. Say you're in surgery and you're under anesthesia and something happens. The doctor has to find that person of who to speak to that you've chosen to make the decisions for you. You could be so far into dementia that you cannot be oriented as to time and place. So the doctors need to know who to talk to. Those are super important things because the doctors and the courts need to know who to speak with, who you trust to make the decisions rather than choosing someone for you. So to me, I think it's most important. That's probably the most important document that I make sure people take into consideration with estate planning is this healthcare directive. I don't charge for it. I include it with a will. So if I'm charging you for a will, it's automatically going to include a power of attorney and a healthcare directive. If you're simply doing a deed reserving life estate with me and you already have a will, I'll give you the healthcare directive and the power of attorney because I think those two elements are so important and no one needs to be without those.
So let's see if we can break down some of that deed reserving a little bit. How does life estate or transfer on death deeds affect estate planning? Respectively.
So we have, again, I've talked about this. We have a lot of different options with tenancy here in Mississippi, joint tenancy with the right of survivorship, tenancy in common, a deed reserving life estate, and a transfer on death deed. All of them afford different pros and cons, benefits and not. To me, when I sit down with someone for estate planning purposes, I like to talk through what they want to happen at death and the best way to avoid probate. The best way to avoid probate as it relates to titling your property are these deed reserving life estates or transfer on death deeds. We have two options. With a deed reserving life estate, you can transfer the property. Let's give an example of my parents. They can keep their joint tenancy with the right of survivorship. So let's say my mom passes away and then my dad owns the property. Then once he's passed away, if he did a deed reserving life estate and said that he wanted the property to go to my brother and I once he's passed away, that automatically happens upon his death. So there's no need for probate. It's an automatic transfer from the person that has held this life estate interest. A life estate interest is basically that you own it for as long as you live. Once both of you have passed away, then it automatically transfers to whomever is receiving the interest. So you retain a life estate. The only negative with that is that, say my dad or my mom, if they ever wanted to sell the property or mortgage it in any way, because my brother and I own interest in the property upon their death, our signatures would be required on that deed for them to sell the property or to mortgage it in some way. This is a good idea too for if you have parents that are getting older and the worry is that they're going to be taken advantage of by people, say they're going to sell the property to someone below market value. It's kind of an extra layer because your signature is required. So there's a good and it's good and bad. Some people don't like that they have to have their child or whomever they're giving the property sign off on it if they want to sell it or mortgage it. But most of the time people trust their children to do that. Whatever's in the best interest of the parents and the child, they know that their child is going to take care of them and they'll sign it if they need to. So we say that a deed reserving life estate is not revocable without those remaindermen's signatures. Whereas there's a transfer on death deed, it is revocable without signatures. So again, say my mom and dad say that they want the property to go to my brother and I at death, and they do this transfer on death deed, they can revoke that at any time or sell the property or mortgage the property without our signatures. However, once they pass away, they could not sell the property or mortgage the property, whomever inherits it, for 3 years and 90 days after my parents' death. The reason for that is creditors' claims can still attach to the property. So we as title companies can't write title insurance on the property if there's a transfer on death deed and 3 years and 90 days have not passed. So usually it's not a good option for people because they're in the parent's intent to their children is that the proceeds from the sale of that home is going to be their children's inheritance. So when there's this red tape or timeline that they have to wait in order to sell the property, they don't want to do that. It always makes the most sense to me when, say, we are in Mississippi, say they have a family farm, and this family farm has been in the property for a long time. The family will do a transfer on death deed because it doesn't matter how long. They want the property to stay in the family, and that's just an extra layer of a buffer in time to make sure that they don't just sell it once the parents pass away. They want to make sure it stays in the family, so they do a transfer on death deed because there's that time buffer. But it's really the difference between a deed reserving life estate. It transfers automatically on death. No creditor claims can attach to it. But if there's a transfer on death deed, the creditor claims can attach to the property, and there's that time buffer on when they can sell it or mortgage it.
So are there specific legal considerations or requirements individuals should be aware of when creating estate planning documents?
Every situation is different. So I think when someone comes in to meet with me, there's no specific considerations. It's just talking through their family history. It's talking through what they want to happen upon their death. It may be, again, like we've talked about, that they want to leave a child out. There may be a situation where we create a testamentary trust for a child that may have had drug issues in the past, and we put these certain requirements on their when and where they can get money once they inherit it. So let's say the parent passes away, a child has a history of drug abuse. There have been times when parents put in a testamentary trust for that child to say they have to test negative for any drugs and alcohol. They couldn't have been in jail. They have to get some kind of degree before they're able to get their money. We can always tailor the situation to your needs. So there's no certain consideration. It's just talking through those things with me, another attorney. But again, I'm here to be your friend and make sure everything you want happens. And it just so happens that I'm also an attorney. So that's how I like to handle those situations. Everyone is different. So my attorney answer is, it just depends on the situation.
So as we wrap up, for someone who hasn't started estate planning yet, what advice would you give them to begin the process?
Come see me. Let's talk through it. Let's go through your situation. It's not going to be nearly as daunting as you think it's going to be. Most of the time when people come in, they say, oh, I've been needing to do this for years. I've just been so nervous. I think I need all of these documents. Just come see me or call me. We can set up an appointment. It can be by phone. It can be by Zoom. It can be in person. There's no need to have you personally in my office the first time we talk about things. I don't charge a consult fee. Let's just talk. I want to help you. I want to make sure that your wishes are realized by your estate planning documents, by the court, by your family, whoever it may be. I just want to make sure that you're covered. You feel comfortable. Most of the time when people leave my office, they say, I can breathe a sigh of relief. This wasn't nearly as bad as I thought it was going to be. It's just getting through the doors or getting on the phone with me. It's not going to be bad. Let's just talk through it. And I promise I can help you through it.
That's good advice. Everyone get started. Nicole is giving you a lot of options on how to get started. So everyone, thanks so much for tuning in to Close to Home with Nicole Sullivan. For more information or to connect with Nicole, visit Sullivan Law Firm, PLLC.com, or find her on social media. Nicole, thanks for your time today.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.